My name is Audrey Simms. I am 66 years old, and 12 days after my husband died, my stepson set a duffel bag by my feet in the dining room and told me I had married Walt for the property. He did not shout. Lance never shouted. He said it the way you read a weather report. Flat, certain, already decided. His sister sat across from him. Walt's older sister, Connie, was in the corner chair with her reading glasses on, though she had nothing to read. 3 cousins stood in the kitchen doorway. I had made a full pot of coffee. Nobody touched it. What came next, I will get to. But first, you need to know this. Vernon Whitmore drafted every page of the document they handed me that morning. Every clause, every exhibit, every line. 10 months later, in a probate courtroom in Crawfordsville, Indiana, he was asked to read from his own exhibit out loud. He made it through 2 sentences. Then he set the paper down. Welcome to Brave Mom Stories, where women who were told to leave quietly end up being the ones who stay. Subscribe and drop a comment, because this is just getting started. For 28 years, I read other people's documents for a living. St. Francis Regional Hospital on Green Street in Crawfordsville. Medical billing and coding. Starting in 1989, when I was 31 years old and my first marriage had just ended, and I needed a job that paid reliably on Fridays. I took the certification course at Ivy Tech Community College. I passed on the first attempt. I spent the next 2.5 decades in a cubicle with a stack of claim forms and a highlighter, and the patience to go line by line until the numbers reconciled. You want to know what medical coding actually is? It is the belief that every diagnosis, every procedure, every date of service has exactly one correct answer, and your job is to find it. Insurance companies deny claims for 2 reasons: wrong code or missing documentation. If you learn to read an explanation of benefits the way the adjuster reads it, word by word, box by box, looking for what is not there as much as what is, you stop losing. I trained 11 coders before I retired in 2017. Every one of them heard the same thing from me on their first morning. Read the whole form. If a document says it has an attachment, put your hand on the attachment before you sign anything. I met Walt Perkins in October of 2011 because of a billing error. His first wife, Marjorie, had passed from ovarian cancer the previous February. The hospital had billed her final 2 months of treatment to the wrong secondary insurer, and Walt had been fighting a $14,000 collection balance for 8 months. He drove to the billing office himself, which almost nobody does. He had a manila folder with every explanation of benefits going back to Marjorie's first infusion, organized by date and paper-clipped by quarter. He set that folder on my desk and said quietly, "I don't know if I'm right, but I know something is wrong." He was right. The secondary payer had been coded incorrectly on the original claim. It took me 40 minutes to find it and 3 weeks to get it corrected. The balance was cleared in full. Walt called the office to say thank you, and I could tell from his voice that it was the first piece of good news he had received since February. He was 61, silver hair, a handshake that lasted about half a second longer than most people's. He owned and managed 4 small commercial properties in Montgomery County, a strip of rental units on Waynetown Road, a storage facility out on the highway, and 2 retail spaces downtown he had been holding since the late 90s. He was careful and deliberate, and he did not say things he did not mean. We married on a Saturday afternoon in June of 2014. In his backyard, under a pergola, his son Lance had helped him build the previous summer. 14 people. My sister Frances drove up from Louisville. Walt wore a blue tie and forgot to remove the price tag from his new dress shoes, and Sherry was the one who finally noticed. About 10 minutes before the ceremony, and they both laughed until there were tears on both their faces. 13 years, that is what we got. But first, the prenuptial agreement. I want to be clear about this because it matters later. Vernon Whitmore drew it up. He had handled Walt's properties and legal affairs for 2 decades, and Walt trusted him the way you trust a mechanic who has never once left a problem unfixed. We sat in Vernon's conference room on a Thursday afternoon in April 2014. The document was 41 pages. I read it completely while Vernon and Walt discussed a municipal contract on Waynetown Road. On page 33, paragraph 11 stated that each party acknowledged receipt of the other's full financial disclosure, as detailed in Schedule B, attached hereto. I turned to page 34, signature block, notary line, no Schedule B. I asked about it. Vernon uncapped his pen and looked at Walt, not at me. Standard language, he said. Walt's disclosure is in the file. Walt squeezed my hand under the conference table. He wanted to take me to dinner afterward. He always wanted the difficult part to be finished. I was 53 years old and getting married in 2 months. I let it go. Write that down. It is the only thing in this entire story I let go of, and it nearly cost me everything. Walt Perkins died on a Tuesday in March of 2025. He was 74. His heart gave out in the storage facility's office, sitting at the same desk where he had sat every Tuesday morning for 22 years. The radio was on when they found him. The funeral was on Friday. Lance and Sherry sat in the front row with Connie. I sat beside Walt's oldest friend from the Rotary Club, a man named Harold, who kept apologizing for arriving late. Nobody moved over. 12 days later, on a Sunday afternoon, they came to the house. Lance, Sherry, Connie, and 3 cousins I had met a combined total of 4 times in my life. I made a full pot of coffee. I set out cups. I sat at the oak table Walt and I had hauled up the porch steps together in 2016. Lance said the will was already filed with the court. He said the house had been in the Perkins family since Walt's parents bought it in 1971, he said. And, I am quoting him, that I had come into this family with a duffel bag. My duffel bag was a dark green canvas Land's End, bought in 2003 for a weekend trip. It had been sitting in the back of the bedroom closet for 11 years. When I walked into that dining room, it was already beside the door. Lance had gone and gotten it before anyone sat down, before the coffee, before the chairs were pulled out, before a single word was spoken. He had gone upstairs and pulled it from my closet and placed it where I would have to see it when I walked in. He had gone into that closet first. That is the detail I kept coming back to, sitting there at my own table with my hands in my lap. Sherry cried through most of that afternoon, and she was still the one who said the hardest thing. She looked at me with her chin shaking and said, "We always knew about the properties, Audrey. We always knew that was the reason." I understood where that came from. Walt had sold the Waynetown Road units in 2019 for $380,000. Lance and Sherry found out after the fact, the way people find out things Walt did not want to discuss in advance. He told Sherry he needed the capital for facility repairs. He did not tell her he had set a portion aside in a certificate of deposit he planned to bring up at Christmas, and then didn't, because Walt Perkins found most hard conversations slightly harder than he could manage. He was a good man with an avoidance problem, and I loved him for 20 years anyway. Connie folded her hands and said she thought it was best if I gave everyone some time with the estate. I said, "All right." That is all I said. 2 words, and a year later they were the most expensive 2 words anyone in that room had ever heard me say. Vernon Whitmore called me the following Wednesday. In 11 years of marriage, he had never once addressed me by my married name. "Mrs. Simms," he said, "I want to help you avoid a lengthy process." He told me the will was dated 2010 and left everything to Lance and Sherry in equal shares. He said the prenuptial agreement waived my spousal rights. He said the estate would be resolved smoothly if everyone cooperated. Then, he said something I would not fully understand for another 9 months. He said there was a window under Indiana law, 90 days from the appointment of the personal representative, to file a spousal claim. He said that window would close, and he would hate to see me spend money chasing a fight I could not win. He said it pleasantly. The way you say something when you want a person to remember the deadline and forget everything else. I asked him one question, whether Walt had ever spoken to him about updating the will. There was a pause, 3 or 4 seconds. "Not that I recall," he said. 28 years of reading insurance files while adjusters talked around what they meant, and I can tell you exactly what a person sounds like when they consult their memory before answering. I moved to a one-bedroom apartment on Market Street in Crawfordsville in April. $1,200 a month, electric baseboard heat, a window that faces the old courthouse dome. My pension from St. Francis is $1,980 a month. Social Security covers the difference. I was not destitute, I was erased. My name appeared on the marriage license, on the joint checking account we opened in 2017, and on one other document connected to that household. The prenuptial agreement that Walt's attorney had written to keep me from claiming anything. I took 2 rolling suitcases, my winter coat, and Walt's old quilted flannel vest from the hook by the kitchen door. Brown plaid, both elbows worn thin, smelling like the inside of his truck. Lance looked at it when I lifted it from the hook. For 1 second, I thought he was going to tell me to put it back. "Fine," he said. "I want to tell you how I left that house because it is the last ordinary thing I did before everything changed." Sherry stood in the kitchen and counted out loud. 15 minutes. 12. 8. She did not do it to be cruel. She did it because the counting was the only control she had left, and grief does strange things to the way we reach for it. I understood that. It did not make it easier. I made it to the CVS parking lot on Elm Street before I pulled in, put on my flashers, and cried for about 10 minutes with Walt's flannel vest across the passenger seat. I hung that vest on the hook behind my apartment door when I got home. I did not go through the pockets. Not that night, not that summer. People tell you grief is a wave. In my experience, grief is a garment you walk past 400 times because you are not ready to find a gas receipt with his handwriting still on it. In July, my friend Bea took me to lunch at the diner on Pike Street. Bea had worked the front desk at St. Francis for 31 years, and she called me every single week after Walt died, which made her the only person on that side of my life who did. She put her fork down halfway through her chicken salad and said, "Audrey, have you looked at the estate file?" I said, "What do you mean?" She looked at me the way you look at someone who has temporarily forgotten what they are good at. It is public record. The day Vernon probated that will, it was open to anyone who walked up and asked for it. I knew that. I had coordinated insurance claims against estate assets a dozen times in my career. I had asked county clerks for probate files as a routine part of my job. "I'm not ready," I said, "to sit down with a document and find my name not in it." Bea paid for lunch. On the way out, she said one thing that stayed in me like a stone for the next 5 months. "They are counting on you being too proud to look." The 90-day window closed in late July. I knew the date. Vernon had given it to me on the phone in April with that smooth, measured voice. I called one attorney in June, a woman named Fiona Gould, whose office was above a dry cleaner on Washington Street, who handled nothing but estates and probate. She explained the spousal election. She explained the prenuptial agreement would be raised against me. She said it would be a fight, and fights cost money, and she could not promise the outcome. I said I would think about it. I let the window close. I am going to be honest with you, because this story is only worth your time if I tell it straight. I did not miss that deadline because I was confused or grieving. I missed it because Lance Perkins had told me I married his father for the property, and I made a decision, a clear, deliberate decision, that the most important thing I could do was prove him wrong by touching nothing. If I hired an attorney, every relative in Montgomery County would look at each other and say, "See, we told you." I called that dignity. It was not. It was pride wearing a more respectable name, and the vest was still hanging on my door. On a Thursday morning in the second week of January 2026, I finally went through the pockets. I did it because the left elbow seam had come apart and I wanted to mend it. That was the entire reason. No anniversary, no dream, no moment of clarity. The radiator was knocking, and I wanted something to do with my hands. Right pocket, a gas receipt, a stick of chapstick, 2 quarters and a dime. Left pocket, A folded envelope, heavy cream paper. Whitmore, Alcott and Associates, Attorneys at Law, Crawfordsville, Indiana. The postmark was August 2019. Inside were 9 pages. The first was a cover letter addressed to Walt. The rest was a draft, not for execution, printed in gray across the top of every page. A revised last will and testament. Article 3 gave 1/2 of the residuary estate to his wife, Audrey Simms Perkins, outright and free of trust. In the margin next to Article 3, in Walt's blocky handwriting in blue ballpoint. Audrey gets half, I owe her that, tell Lance in person. Stuck to the cover letter, curled at the corner the way old sticky notes do, a small yellow square in a different hand. Walt, let's discuss before we proceed. Call me after Labor Day, VW. I sat on the floor of that apartment for a long time. Walt had tried. He had walked into that 4th-floor conference room in the summer of 2019 and told Vernon Whitmore he wanted to cut his wife in for half. And Vernon had told him to sleep on it. And Walt had done what Walt always did with hard conversations. He put the letter in his vest pocket and wore that vest to check on the storage facility, and he never mentioned it to me once in the 6 years he had left. He was not a saint. He let his son believe I had influenced the property sales. He let his daughter think I had something to do with decisions he made entirely on his own. He left me in the 2nd row of my own marriage for 13 years and kept saying they would come around. But he wrote Audrey gets half. I owe her that, and he meant to say it out loud, in his own voice, to his own son. He just needed 1 more week. Then another, and then another. Monday morning, I called Fiona Gould and asked for an hour. She read the cover letter. She read the sticky note. She read Article 3 twice. Then she set the pages down and did not soften it. This is not a will, she said. Indiana requires a will to be signed by the testator in front of 2 witnesses. There is no signature here. This document has no legal effect whatsoever. I felt the floor go out. Then she asked, almost as an afterthought, as she was stacking the pages. Out of curiosity, when did Walt actually sign the will they're probating? I stopped with my coat half on. I did not know. Vernon had said 2010. I had never asked for the document. I had never held it. 28 years of reading other people's paperwork, and I had never once looked at my own husband's will. The Montgomery County Courthouse sits on the main square in Crawfordsville. The clerk's office is on the ground floor. I walked in on a Wednesday morning, gave the clerk the decedent's name and year, and asked for the full estate file and docket sheet. He came back with a folder nearly 2 inches thick with a rubber band around it. I carried it to the long table by the window, set down my reading glasses and a legal pad, and the red felt tip pen I had been using since 1994, and I did the thing B said they were counting on me being too proud to do. I started at page 1. The petition for probate was the first document. Vernon Whitmore had signed it on April 14, 2025. Paragraph 2, the decedent died testate, leaving a last will and testament dated November 3, 2010. Paragraph 4, the decedent was survived by his spouse, Audrey Simms, whom the decedent married on June 21, 2014. I circled November 3, 2010. I circled June 21, 2014. The will came first, by 3.5 years. I put my pen down and asked for a copy of the will itself. Article 1. Every will starts the same way. The testator identifies himself and his circumstances so that a court knows, 30 years later, who he was and who he meant. Walt's Article 1 read, I, Walter Raymond Perkins, of Crawfordsville, Montgomery County, Indiana, declare this to be my last will and testament. I am not presently married. I have 2 children, Lance Walter Perkins and Sherry Marie Perkins. He had written that in November of 2010, Marjorie had been gone 9 months. He had never heard my name. I was 42 years old, running claims audits in a regional hospital billing department. That sentence was not written to exclude me. It was not written about me at all. It was written by a man who had just buried his wife and wanted his affairs settled before spring. But Vernon Whitmore had filed it. He had made it Exhibit A in his own petition. He had built his client's entire case on a document that opened with the testator's own words declaring he had no wife. I found Indiana Code 29138 in the County Law Library on the third floor, in the volume on decedents and estates. The pretermitted spouse provision. If a testator marries after making a will, the surviving spouse shall receive the intestate share, unless the will provides a greater share, or unless it appears from the will that the will was made in contemplation of the marriage. Appears from the will, not from what a cousin recalled, not from testimony at a family dinner, from the will itself. And Walt's will opened by saying he was not presently married. Under IC 29121, when a decedent leaves children who are not also children of the surviving spouse, the spouse takes 1/2 of the estate. 1/2. I copied both statutes out longhand on my legal pad. Then I checked the pocket supplement in the back of the volume. Then I pulled the statutes up on the library computer to confirm. 3 sources. Same answer all 3 times. Fiona Gould did not get excited when I laid it out for her. Good attorneys almost never do. She read paragraph 2 and paragraph 4 of Vernon's own petition. She read Article 1 of the will. She got up and pulled a volume from her own shelf, read it standing up without saying anything, then sat back down. "You didn't file the spousal election in July," she said. "No." "Good. It wouldn't have mattered." She explained what I had actually done to myself and what I had not. The election was a separate mechanism, a claim you file against the will with a 90-day deadline. IC 29138 was different. It was not a claim. It was a rule that modified the will by operation of law automatically, the moment Walt married me in June 2014. There was no deadline because there was nothing to elect. The share was simply mine. It had been mine since we stood under that pergola. Vernon Whitmore had spent 9 months running out the wrong clock entirely. "Now the prenup," Fiona said at our next meeting. "Bring me your original." I had it. I keep every document I have ever signed since 1986 in a fireproof lockbox, which Walt thought was excessive. She read paragraph 11. She turned to page 34, signature block, notary stamp, nothing else. She requested a copy of the executed agreement from Vernon's own file, which he had to produce because he had already cited it as a defense. His copy had no Schedule B either. Indiana Code 3111-38. A premarital agreement is unenforceable if the challenging party proves she was not given fair and reasonable disclosure of the other party's property and financial obligations, that she did not sign a written waiver of that right, and that she did not have adequate independent knowledge of it. No Schedule B, no written waiver anywhere in 41 pages. And in April 2014, I had known Walt Perkins for 2.5 years and had never seen a tax return, a bank statement, or a property appraisal in my life. There was one more thing. Fiona found it, and I confirmed it word by word. The prenuptial agreement used the word divorce in 9 separate paragraphs. It did not use the word death once. In May of 2026, Lance demanded a court hearing. He told Vernon he wanted the estate formally confirmed by a judge on the record so I could never come back on them. So Vernon filed a first and final account and a petition for settlement, and the hearing was scheduled for June in probate court. Because I was the surviving spouse, his office was required to serve me the paperwork. It arrived in a manila envelope, a copy of the account, a copy of the petition, and a 2-page joinder form with my name typed at the top. A cover letter from Vernon said the family hoped I would sign to avoid unnecessary expense to the estate. I sat at my kitchen table with that form and my red felt tip pen and read it, both pages, twice. It said I waived formal notice of the hearing. It said I waived any objection to the account as stated. It said I joined in and consented to distribution pursuant to Article 3 of the will. Then I went through it again, looking for what was not there. There was no release. There was no language saying in full satisfaction of all spousal rights. There was no mention of Indiana Code 29138. There was no mention of the term pretermitted spouse anywhere in the document except in the caption where Vernon's secretary had typed my name. Vernon Whitmore had pulled a form he used for adult children and put a widow's name on it. So I signed it, in blue ink, at my own kitchen table, unhurried, 66 years old. I want to be clear about this, because it is the part people get wrong when they tell this story back to me. I was not tricked. I was not being strategic. I meant every word I signed. I had no objection to the accounting. I genuinely consented to the will doing exactly what the will says. I simply also happen to know what a will cannot do. I read everything. That is the job. Fiona mailed the signed form back the same afternoon. She also filed a 3-page claim of pretermitted surviving spouse under IC 29138, served on Vernon's office by certified mail. The return receipt came back signed on a Thursday. The hearing was on a Tuesday morning in June 2026. They all came. Lance in a sport coat, Sherry with her husband, Connie in the second row with her purse in her lap. 3 cousins, including one, a younger man named Dale, who nodded at me in the hallway and then looked at his shoes. I got there at 9:15 with Fiona and my dark green duffel bag, which I had decided to use as a document case because it holds 9 pages flat and because I wanted to. Lance saw the bag in the hallway. Something crossed his face. Recognition, or the beginning of a thought he decided not to finish. He had carried that bag down from my closet with his own hands 14 months ago. Then he said it, quietly, almost gently. "You came into this family with a duffel bag." I said, "Lance, that sentence is not yours. Vernon wrote it. Check the letter he sent to you and Sherry dated March 25, 2025, the same day your father's body was found, before the funeral was even scheduled. You have been saying another man's line for 14 months, and he has been billing you $400 an hour for it." He opened his mouth. The bailiff opened the courtroom door. The probate judge had been on that bench for 12 years. He went through the account methodically, the way I go through an explanation of benefits. Vernon made his presentation. Gross estate, $1,940,000. The properties appraised. The savings accounts, the certificate of deposit Walt had been meaning to discuss at Christmas. Debts paid, taxes paid. Proposed distribution. Equal shares to Lance and Sherry under Article 3 of the will. He introduced my signed consent form as an exhibit and held it up a half-second longer than necessary. "The surviving spouse has joined and consented, Your Honor. Executed May 26th. Fiona's claim was in the file, too. Vernon had answered it in a single paragraph on his letterhead. The spousal election period expired under Indiana law, and the claim was untimely. He had answered a statute he had never looked up in a will he had not reread since he typed it 15 years earlier. Sherry turned around in her seat and smiled at Lance. Lance nodded once. Connie let out a breath she had been holding since the parking lot. Then the judge took off his reading glasses and let them hang on their cord. "Mr. Whitmore, your petition states the decedent married Miss Simms in June of 2014. That is correct, Your Honor. And the will is dated November 2010. Yes, Your Honor. He married after he made it. Read me Article 1. There was a pause. I will describe it as accurately as I can, because I have thought about it more than I should. 2 seconds, maybe 3. The same pause I had heard on the telephone in April of 2025 when I asked whether Walt had ever spoken to him about changing the will. Vernon picked up his own exhibit. He cleared his throat. He began. "I, Walter Raymond Perkins of Crawfordsville, Montgomery County, Indiana, declare this to be my last will and testament. I am not." He stopped. He set the paper down. He did not pick it back up. The window unit in the courtroom rattled. Somebody's chair creaked. Sherry said, "What?" out loud, and her husband put a hand on her arm. The judge looked at Fiona. "Counsel, I assume you're about to say IC 29138. "Yes, Your Honor." Vernon came back up arguing. The election deadline, the prenuptial agreement, the consent form I had signed with my own hand 16 days earlier, right there in his firm's own format. His voice went up for the first time all morning. Fiona stood and used about 30 seconds. "The pretermitted spouse statute is not an election, Your Honor. There is no deadline. The share vested by operation of law on the date of the marriage. The consent form waives notice and objection to the accounting. It contains no release of any statutory right. It does not mention Title 29 anywhere in its text. The prenuptial agreement references a Schedule B that does not exist in either party's copy. IC 31-1138. Vernon said, "Your Honor, that is a technicality." I stood up. Once. It was the only time I stood up all morning, and I did not raise my voice, because I have never once in my life gotten what I needed by raising my voice. "Mr. Whitmore," I said, "you wrote every word of that form. I only read it." Then I sat back down. The judge ruled from the bench, which I was told he rarely did. IC 29-138 applied on the face of the record. The exception required contemplation of the specific marriage to appear from the will itself, and Article 1 said precisely the opposite. The joinder I signed waived notice and objection to the accounting, and nothing further. The premarital agreement failed for want of the required disclosure. Under IC 29-121, the surviving spouse takes one half of $1 million. $940,000 is $970,000. Lance hit the table with his open hand and said his father would never have wanted this. The bailiff stepped forward. The judge said his name, and then said it again. Sherry did not shout. She turned around in her chair and looked at me for a few seconds. Then she said very quietly, "He told me once he owed you something. I thought he was just talking." She turned back around and did not look at me again. Connie stared at the wall above the flag and did not move. The judge, closing his files, added one more thing in the flattest voice in that room. "Mr. Whitmore, before your fee petition is heard, I would strongly suggest you retain separate counsel." The court entered a decree awarding me one half of the estate. House on Maple Avenue, appraised at $280,000, was set over to me as part of my share because I asked for it and because there was no legal reason to deny it. Vernon's fee petition was heard in September. He asked for $28,000. He was awarded less than half. A disciplinary matter is pending with the Indiana Supreme Court. Lance and Sherry hired a firm in Indianapolis. Their civil action against Vernon Whitmore is still in discovery. I did not take a single dollar more than Indiana law gives a wife. I did not take a single dollar less. On a Saturday in October, I drove to the house with the green duffel bag on the passenger seat. I unlocked my own front door and set it down in the entryway, right where Lance had placed it 14 months before. The red felt tip pen went back in the drawer by the telephone, same drawer it had always been in. The first thing I did was not the furnace, and it was not the gutters. I went out to the back deck with a hammer and 2 wood screws and fixed the loose post on the railing. The third post from the left, the one Walt had wrapped in duct tape in the spring of 2022 and promised himself he would get to properly before the next winter. Then the winter after that. It took 11 minutes. Walt's flannel vest is on the hook by the kitchen door where it belongs. I mended the elbow seam on a Sunday afternoon in November and hung it back up, and I have not touched the pocket since. Sherry called me once in December. I let her talk for 8 minutes. She told me about a conversation she'd had with her father in his truck. He had mentioned, once, that he owed me something, and she had not understood what he meant at the time. She asked whether I would consider selling the house back to the family at the appraised value. I said no. Then I said, "The lilac bush I planted by the fence post is going to be beautiful in April. You are welcome to come see it any spring you want. Call first." She said she would think about it. She has not called again. I have not changed my number, and I am not going to. If you take one thing from me today, let it be this. Being too proud to read the document is not the same as being above the fight. The day I finally understood the difference was the day I stopped waiting for someone to hand me what I was owed and walked up to a public counter and asked to see the file myself. Nobody gave me that decree. I did not outmaneuver anyone. I walked into a building I had walked past for 30 years, said my husband's name to a clerk, and asked for everything that had been filed. Then I sat down at a long table by a window and I read every page. That is the job. It always was, and it is never too late to do it.